The courtroom on the 14th floor of the Harwick Federal Building went quiet at 9:47 in the morning. Not the polite quiet of a room waiting for something, but the specific silence of a room that has already decided how things are going to go. Judge Aldous Pemberton set down his coffee cup without looking at it. He had been doing that for 31 years. He knew exactly where the edge of the bench was. He knew exactly how far a junior attorney could push an argument before he stopped them. He knew, or believed he knew, the precise weight of every person who walked through those double oak doors. He had already weighed Jonah Solis. Jonah was 26. He had a second-hand suit that fit well enough across the shoulders, but pulled slightly at the left sleeve, where he'd had it altered twice, because he couldn't afford a new one. His shoes were clean. His briefcase was a canvas messenger bag with a broken clasp that he held shut with his left hand whenever he set it down. He had graduated third in his class at Southwestern Law School. Not Harvard, not Yale, not the kind of school that made judges lean forward when they read a resume. He had taken the public defender's office because it was the only offer that came with health insurance, and his younger sister, Maeve, needed health insurance. Maeve was 17. She had been 17 for 4 months. She had a condition that required medication that cost $412 a month without coverage. And their mother had stopped being reliable about most things 3 years ago when their father left, and Jonah had become the kind of older brother who did not talk about the things he did without being asked. He just did them. He had passed the bar on his first attempt. He had worked 18-hour days for 2 years in an office with a broken radiator and a window that didn't seal properly in winter. He had won 11 of his last 14 cases, a record that his supervisor had described in the break room, offhandedly, as actually not bad for someone out of Southwestern. Jonah had smiled and poured himself a coffee and gone back to his desk. The case that morning was State v. Ruben Ochoa. Ruben was 43, a warehouse supervisor, charged with a single count of aggravated assault after an incident outside a bar in the Linwood district. The prosecution's case rested almost entirely on the testimony of one witness and a piece of security footage that Jonah had watched 47 times on his laptop in his apartment at 2 in the morning, pausing and replaying the same 11 seconds over and over while Maeve slept in the next room. He had seen something. He wasn't sure anyone else had seen it. The prosecuting attorney was a man named Gerald Forsyth Crane. The full name appeared on all his court filings, and he used it, all 3 parts, every time the way certain men announce themselves as a statement of position. Crane was 54. He had gone to Georgetown. He had 17 years in the DA's office and a conviction rate he mentioned at every bar association dinner. He wore cufflinks. Not ostentatious ones, just quiet, expensive, understated cufflinks that said he had never needed to think about cufflinks. When Jonah had introduced himself in the hallway before the session, Crane had looked at him the way people look at a waiter who has arrived at the wrong table. Polite enough. Dismissive in a way that didn't bother to hide itself. "Solis," Crane had said, glancing at the messenger bag. "Public defender?" "Yes." Crane had nodded once, the way you nod when someone confirms something you already assumed, and walked away. Judge Pemberton had a similar quality. He was not a cruel man. That was the thing about him. People who knew him well would have insisted on that point. He was not cruel. He was simply a man who had, over 31 years, developed a very efficient internal filing system, and certain files got opened, and certain files did not, and a 26-year-old public defender from Southwestern with a canvas bag and an altered suit jacket went into a file that did not receive a great deal of his attention. Jonah knew this. He had known it walking in. He had known it the night before, sitting at his kitchen table with the case files spread in front of him and a yellow legal pad covered in handwriting, and he had felt the specific weight of being underestimated settle over him the way it always did. Familiar, unwelcome, something he had learned not to argue with directly. You didn't argue with it, you worked. The morning session opened with Crane presenting the prosecution's timeline. He was good. Jonah acknowledged that privately, watching the jury. Crane spoke with the particular confidence of someone who has done this so many times that uncertainty has become physically impossible. He walked the jury through the evening of March 8th, the bar, the parking lot, the altercation, Ruben Ochoa's hand raised, the witness account, the medical report on the victim's injuries. He presented the security footage, 11 seconds, a parking lot, a street light at the far edge of the frame, 2 figures at the center of the image, and a third figure partially visible at the left margin, and then movement, and then one figure on the ground. The jury watched it. Some of them leaned forward. Crane said, "The footage clearly shows the defendant striking the victim. The defense will attempt to complicate what you can see with your own eyes. Don't let them," he said it, "the way you say something that is simply true." Judge Pemberton listened without expression. He made a note. He glanced once at Jonah with the mild, incurious look of someone checking a clock. Jonah did not react. He was writing on his legal pad in small, precise handwriting, and he did not look up. And the jury, who were watching both attorneys because juries always watch both attorneys, saw a young man who appeared calm. He was calm. That was the thing people misread about Jonah Solis. They saw the second-hand suit and the canvas bag and the school they'd never heard of, and they constructed a narrative around those details. And the narrative said, nervous, outmatched, going through the motions. They missed the stillness. They missed the way his eyes moved when he was listening. They missed the legal pad, which by that point in the morning contained 43 separate notes, organized by timestamp, cross-referenced in the margin. When Crane finished, Judge Pemberton looked at Jonah. Counsel. Jonah stood. There was a small, almost imperceptible shift in the room when he stood. The kind of shift that happens when a room has already decided what it expects to see, and then wonders, briefly, if it might be wrong. It was nothing he did. He simply stood the way a person stands when they are not performing standing. He picked up his legal pad. He did not pick up the messenger bag. He said, "Your Honor, members of the jury, the prosecution has shown you 11 seconds of footage and asked you to accept what you see. I'm going to ask you to look at what the footage doesn't show, and more specifically, where the light is coming from." Crane shifted in his seat. A small movement. Jonah noticed it. The security camera on the Linwood parking lot is mounted at the northeast corner of the building, Jonah continued. The streetlight that appears at the far left edge of the footage is a sodium vapor light, mounted on a city pole, which, according to the Department of Public Works maintenance logs, entered into evidence as Exhibit 7, had been operating at 40% output since February 22nd due to a ballast fault that had not yet been repaired. He paused. One juror in the second row, a woman in her 50s with reading glasses pushed up on her forehead, had tilted her head slightly. Jonah had noticed her in voir dire. She had worked as an office manager for a commercial property company for 20 years. She understood maintenance logs. He kept going. At 40% output, that light does not illuminate the center of the parking lot where the altercation occurred. At 40% output, with the camera angle and the available light from the bar's exterior signage, which is red, and which the camera's sensor registers differently than white light. What you see in that footage is not two clearly distinguishable figures. What you see is a shadow event, a silhouette against a low-contrast background. He walked to the evidence display. He had a still frame from the footage, enlarged, printed on a board. He set it up without hurrying. The prosecution's witness, Mr. Boone. He did not use the first name. He never used first names in court. It created an intimacy that was not warranted. Testified that he saw the defendant's face clearly at the moment of impact. Mr. Boone was standing here. Jonah pointed to a spot on a diagram he had prepared. 11 feet from the altercation, at an angle of approximately 40 degrees from the light source, at 11:42 p.m. He let the jury look at the diagram. I would like to show you one additional piece of information that the prosecution did not include in their presentation. Crane was on his feet. Objection, Your Honor. If counsel is introducing new evidence, it's in the discovery, Your Honor, Jonah said without raising his voice. Exhibit 14. The prosecution received it on the same date we did. Judge Pemberton looked at Crane. Something moved behind the judge's eyes, not quite interest, but the precursor to it, the moment before a file gets opened that wasn't supposed to be opened. Exhibit 14 is in the record. Overruled. Continue, Mr. Solis. Jonah had been waiting for that, not the ruling. He had expected the ruling. He had been waiting for the judge to say his name with that particular inflection. Not dismissive, not yet invested. Somewhere in between, a door slightly ajar. He placed Exhibit 14 on the display beside the still frame. It was a second security camera recording, not from the Linwood parking lot, from the ATM vestibule of the credit union on the corner of Linwood and Farwell, 40 feet away, with a different angle and a different light source, a bright, direct fluorescent, and a timestamp that ran concurrent with the first footage. In this footage, the figure the prosecution had identified as Ruben Ochoa was visible in a way that the parking lot camera had not made possible. The figure had a tattoo on the back of the right hand. A specific tattoo, a compass rose, distinctive, documented in booking photos when Ruben Ochoa had been processed. In the ATM footage, the arm that was raised, the arm that Crane had said clearly, on camera, striking the victim, did not have a tattoo. The jury saw it at the same moment that Jonah said it. He had timed the explanation to land at the exact second they were looking at the image, so that his words and their eyes arrived at the same place simultaneously. And the room experienced that specific electric clarity that happens when something becomes suddenly and irreversibly understood. Crane was very still. Judge Pemberton was not still. He had leaned forward. His coffee cup was untouched. For the first time since Jonah had entered that courtroom, the judge was looking at him the way you look at something you need to understand, rather than something you have already categorized. Jonah said quietly, "The arm in the prosecution's footage does not belong to Ruben Ochoa." There was no dramatic outburst. This was not a movie. The courtroom remained orderly, but the air in the room had changed, the way air changes when a window opens somewhere, a movement that is not dramatic and is not subtle and cannot be ignored. One juror exhaled. Jonah sat down. He did not look at Crane. He did not look at the judge. He wrote a single word on his legal pad and put the pen down. Later, days later, after the jury had deliberated for 4 hours and returned a not guilty verdict, after Ruben Ochoa had shaken Jonah's hand in the hallway with both of his hands, after the paperwork and the debrief with his supervisor, who had said good work in the particular tone of a man recalibrating. Jonah was in the parking garage of the Harwick building, keys in hand, when he heard footsteps behind him. He turned. Gerald Forsyth Crane was walking toward him. He had removed his suit jacket and was carrying it over one arm. Without the jacket, without the courtroom, without the 17-year record, and the Georgetown degree as backdrop, he looked like what he was. A man in his 50s who had just lost a case he had been certain he would win, and who was working out what that meant about something he had believed about himself. He stopped about 6 feet away. "That ATM footage," Crane said. "How long did it take you to find it?" Jonah considered the question. 3 weeks, he said. "I walked the block. There are 11 cameras within sight of that corner. 8 of them are privately owned. I contacted 7 property managers and 2 business owners to get access." Crane was quiet for a moment. "You went to Southwestern." "I did. That's not..." Crane stopped. "Started differently. The analysis of the light output, the ballast fault. That was..." He seemed to be having some difficulty with the word. "That was rigorous. Thank you." Another pause. The parking garage was mostly empty. A car passed on the level above them, its tires echoing on the concrete. "I misjudged the case," Crane said. He said it carefully, like a man who does not often say that sentence and is gauging how it feels in his mouth. Jonah nodded once. "I know." Crane looked at him, really looked at him, in a way that had not happened in the hallway that morning, in a way that had not happened when he glanced at the canvas bag and made the calculation he'd made. Something in his face shifted, not into apology, exactly, into recognition, the kind that comes too late to change the morning, but arrives in time to change something smaller, something the person it happens to will carry differently afterward. "You're going to be someone," Crane said. It was meant as a compliment. It was the best he could offer. Jonah unlocked his car. "I already am," he said. Not unkindly, simply as a fact, the way you state something that has been true for a while and just hadn't been acknowledged by the right people yet. He drove home. Maeve was at the kitchen table doing homework, her biology textbook open, her headphones around her neck. She looked up when he came in. "How'd it go?" "Good," he said. She studied him the way younger siblings study older ones, reading something in the posture, the eyes, the exact quality of the word. "Did you win?" "Yeah." She nodded, like this was expected, because to her it was. She had been watching him work her entire life. She had seen him at that kitchen table at 2 in the morning. She had seen the legal pad, the files, the yellow highlighter. He went through a pack of every 2 weeks. She had seen what nobody in that courtroom had seen, because she had grown up inside the life that they had only glimpsed the outside of. She turned back to her textbook. Jonah put his keys on the hook by the door. The hook he had installed himself. A $5 piece of hardware from the Home Depot on Crenshaw, because the apartment hadn't had one, and he went to the kitchen and started making dinner, because dinner still needed to be made, and Maeve still needed to eat. And the work was not the dramatic moment in the parking garage, and it was not the 4 hours the jury had deliberated, and it was not the word the judge had finally said with something different in his voice. The work was this: the 2 in the morning, the 11 cameras, the 7 property managers, the maintenance logs and the ballast vault, and the 43 notes in small, precise handwriting on a legal pad that nobody in that courtroom had seen until it mattered. There is a version of this story where Jonah Solis walks into that courtroom and someone, the judge, the opposing counsel, a bailiff, anyone, looks at him and sees what he actually is. That version does not exist. That is not how this works, and anyone who tells you otherwise has not spent time in a Harwick federal parking garage at 5:30 in the evening. What exists is the other version, the version where you do the work anyway, where you walk the block and knock on 7 doors and watch 11 seconds of footage 47 times, until you see what is actually there rather than what you've been told to see. Where you stand up in a room that has already decided about you, and you say, "Look closer, look at where the light is coming from." Because here is what the courtroom did not know about Jonah Solis, what Crane did not know, what Judge Pemberton did not know until the moment he leaned forward and could not lean back. The second-hand suit was pressed. The canvas bag held everything he needed, and the school on his resume, the one nobody recognized, the one that produced a man who walked a city block 3 weeks before trial counting cameras, that school had taught him something no institution with a famous name had bothered to make room for. It had taught him that the people who underestimate you are not your problem. They are your advantage. He stirred the pan. Maeve turned a page. Outside, the city went on being the city, loud and indifferent, and full of parking lots and sodium vapor lights and 11-second videos that almost told the truth. Almost.